Dr. Edwards, with that, I think we're fine to start the meeting.
Thank you very much. So good afternoon and welcome to the Telephonic Rules and Regulations Committee meeting for August the 4th, 2020. I'm Regent Veronica Muskies-Edwards, chair of this committee. The time is 2:01 p.m. Notice of this meeting was provided to the Secretary of State as required by Texas Open Meetings Act, Government Code, Chapter 551. Please note that the audio of this meeting is being broadcast live. Before we take roll call, I'd like to remind everyone to please mute their phones unless you need to speak. And Laura, could we please begin roll call with committee members and any other regents that may be on the call?
Sure. Good afternoon. Regent Edwards.
Here.
Thank you. Regent Flores.
Here.
Regent Tinsley.
Here.
Regent Scott.
Here.
Regent Harrell.
Here.
And we have Student Regent Lee.
I'm here.
Thank you. Are there any other regents joining us? Okay, thank you.
Thank you again. May we now have roll call for System Office Representative.
Chancellor McCall.
Here.
Dr. Gomez.
Here.
Nellie Herrera.
Here.
Daniel Harper.
Here.
Therese Sternenberg.
Here.
Derek Alexander.
Here.
Sean Cunningham.
Here.
Carol Foss.
Here.
Do we have Dr. Hayek?
Here.
Thank you. Any other system staff on the call? Okay, thank you.
So thank you again. May we now have roll call for component representatives.
Let's start with Lamar University.
Ken Evans and Jeremy Altop.
Thank you. Sam Houston.
Carlos Hernandez.
Thank you, Carlos. Sol Ross.
Yvonne Realivas.
Hey, I'm here.
I heard Yvonne, and who else?
This is Pete Gallego.
Thank you, President Gallego.
And Mike Pacheco.
And Mike. Thank you, Mike. Texas State University.
Denise Trout, Lisa Lloyd, Eric Algo, Mary Ellen Cavett, and Ken Pierce.
Thank you all. LIT. Do we have anyone from LIT on the call?
Bonnie Albright, Angela Hill, and Lonnie Howard.
Thank you. Lamar State College Orange.
Tom Johnson, Mary Wickland, Wendy Elmore, and Patty Collins.
Thank you. And finally, Lamar State College Port Arthur.
Betty Renard and Mary Wickland.
And a train. Thank you. All right, that concludes roll call.
Thank you for the roll call. And with that, I'd like to note that Dr. Gomez briefed me on the agenda items prior to the meeting. So at this time, I'd ask that he present the Rules and Regulations Committee agenda items. Dr. Gomez?
Thank you, Madam Chair, Mr. Chairman of the Board, Regents, Chancellor, and colleagues. I love these Cecil B. DeMille calls with a cast of thousands. This is great. Thank you for attending. First of all, I have to tell you that we wouldn't be having this call in quite this way, at least, but for the fact that the Federal Department of Education promulgated rules on sexual misconduct and then gave us until August 14 to get them implemented. And August 14, of course, is next week when the board meets. Normally, we would have this vetting process through the presidents and the campuses before presenting to the board. But I wanted to tell you that if you look at R&R page 1, Rules and Regulations 1, We've got rules in 4 different areas. The first 4 relate to sexual misconduct policy. The 5th one is a non-discrimination policy amendment to our non-discrimination policy. Number 6 is the IT policy. There are 2 rules there that I hope that Vice President Pierce, the President, and Vice President Pierce at Texas State will speak to. And finally, 7 and 8 are finance rules proffered by the Vice Chancellor and Chief Financial Officer, and I hope that he will speak to those. Now, taking the first 4, if you turn to page R&R 2 through 5, I'm going to go through the highlights. What we had here was the federal government promulgating, the Department of Education promulgating 2,000 pages of prelude or prefix or whatever you want to call it, introduction to the rules, and just a few pages of rules. We've been anticipating these rules being promulgated since last year, and the component Title IX staff, as well as the system staff within the Office of General Counsel, led by Deputy General Counsel Nellie Arreta, have worked very, very hard on this and have been prepared for this and have done a marvelous job, essentially of giving you 59 pages of rules. And because of the changes in different areas, we decided not to provide this to you in legislative format. It would have been, I think I saw an early draft, very difficult to follow, almost unintelligible. What I'm going to hit at, if you're looking in the next 4 pages from 2 to 5, I'm going to go over those fairly quickly. And I'm going to hit at the highlights of what the changes are. And Section 1 is an introduction. It affirms the values of the system and of the components. There's a glossary section, Section 2, Section 3. The principal changes here are that there was some question, and the Department of Education wanted and promoted in a hearing charging somebody with sexual misconduct to implement a clear and convincing standard of proof, which is a very high standard. Our customary standard in student discipline cases as well as in faculty cases is a preponderance of the evidence, which is, of course, more likely true than not the so-called 51% rule. And that's what we have done. So that's not really a change. The second, if you turn to R&R 3 at the top of the page, these rules also deal with emergency removal from campus of in certain circumstances, and I will get to those in just a few minutes, because those are dealt with not in the sexual misconduct policy, but in the board's rules and regulations in 3 different chapters. Section 4 deals with reporting incidents of sexual misconduct. The significance of this as well is that the legislature has imposed certain reporting requirements, and the board dealt with those in May, so there's no need to go over those in particular. Section 5 deals with the classification of sexual misconduct and what is sexual misconduct under federal regulations. And there's other misconduct other than harassment. There's dating violence and stalking and other forms of sexual misconduct. Section 6 is significant because it establishes the process to be followed by the Title IX coordinator on the campuses during the pre-investigation and into the investigation stages. And then 7 gets into the Section 7 on page R&R 4. That gets into the specifics of the sexual misconduct grievance process on the campuses. There are three aspects of this that I want to point out to you. The first is that the federal government, through the Department of Education, is now requiring a signed complaint before proceeding on a sexual misconduct investigation and essentially hearing. You have to have somebody that's coming forward and saying, I'm telling you in writing, this is what happened to me, and I want you to deal with it. And that's doesn't change anything materially that we're doing, but it does provide a level of process to anyone who would be accused on the campuses. So the individual who's making the accusation, there are no anonymous complaints. They are required to come forward. Secondly, and this is a very material change, there is a requirement now that the schools, the components, the campuses provide an advisor for not only the person who has made the complaint, but also for the person who is charged with the misconduct. The advisor is there for the purposes of cross-examination and presumably to just provide guidance to the individual who is being charged, principally in the student area, and especially in the student area, but an advisor. The advisor does not have to be a lawyer. It's not required to be a lawyer, but we are required to provide an advisor. Now, the general counsels of the 6 systems have talked about this at some length for the last year, and one of the recommendations that's come forward from one of the systems with a law school, I'll tell you, it's a University of Houston. They are proposing to create a group of law students statewide that might serve this purpose. I don't know whether that's going to come to fruition, but we do have some thoughts, and we'll provide some guidance to the campuses as to what an advisor might look like, and the Office of General Counsel, as well as I'm sure your Title IX coordinators would be involved in this process, but would provide guidance and training on that if need be. The third aspect is a change from what the prior administration in Washington, the process that they implemented, I think around 2011, and that is that somebody could make a complaint and that there would be no live cross-examination. The reason for this was to make it easier for the complainant. And now this administration has said, no, if you're going to charge somebody with sexual misconduct, especially if you're going to impact their right to continue in school or presumably their right to continue to work for you as a tenured professor, you're going to have to have live cross-examination. It can be contemporaneous. People can be in different rooms, but it has to be live cross-examination. I have to tell you that many courts have, in the interim, come forward and have spoken to that and actually ruled that live cross-examination is, in fact, required by the 14th Amendment due process clause. So I think that's something that, we need to be where we need to be. And in practice, we've had a major hearing come through. The board ruled on this and made a decision, I believe, in May, and we did end up having live cross-examination in that when we went through the tenure revocation process. And I don't think this will change how we do business. Section 9 is the grievance process, and that just simply describes what those procedures are and how how the decision is made, and I will talk about that with respect to emergency removal in just a second. Number 9 provides an appeal process. This is something that we've always had. And then finally, Section 10 deals principally with the responsibilities for training and for reporting sexual misconduct. Now, in Texas, by action of the legislature, by statute passed by the legislature last session, every single person on the campus has a duty to report sexual misconduct. And the president has a duty to report annually to the Board of Regents and on sexual misconduct matters, and eventually that report is submitted to the Higher Education Coordinating Board. But that's essentially the sexual misconduct policy. You're looking at 59 pages, plus the changes that we've made to the rules and regulations themselves. Does anybody have any questions that they would like to ask on that?
Dr. Gomez, this is Don.
Yes, sir.
Do we know at all what the impact is going to be on our campuses by implementing these policies, which I have no problems with, but that it's going to be time-consuming and financially burdened?
Well, you're right, except that remember that we've been working and thinking and discussing this for a year, and the Deputy General Counsel has worked with the Title IX coordinators and presidents. You have, each and every one of you have reason to be tremendously proud of your folks. And Nellie, I wish you would address that, because I think this is well in hand, Regent Flores, but I'd like Nellie to give you the specifics of what that committee has been discussing.
Please.
Dr. Gomez, thank you. I'm happy to address that. And Regent Flores, you make an excellent point. Actually, the promulgation of these new federal guidelines the effect is that they are placing on all of our campuses additional responsibilities that were not there before. For example, the appointment of an advisor, that we never had to appoint an advisor before. And now all campuses are required to appoint an advisor to a respondent or complainant once we are in this grievance process for Title IX sexual harassment cases. And that is why so many of these institutions in Texas are trying to figure out how best to address that. Should the advisor be somebody internally? Should this be something that's outsourced? Should you try to get somebody with a legal background, even though the federal regulations specifically say that advisors do not have to be attorneys? They simply need to be informed of the policy, aware of the requirements under the federal regulations, so they have to be trained. And that brings the second point up. Not only do components now have to assign an advisor in these cases where we never had to do that before, we are also needing to make sure that we double our efforts, so to speak, when it comes to training. Training is going to be key here, and we are going to be assessed and judged by the Department of Education on how we are training all of the decision makers who have a role in these Title IX matters. The decision makers, the Title IX coordinators themselves, the investigators, and the appellate authority, even the people who are going to be in charge of conducting informal resolutions of these matters. So training is a very big and important component. And I have to give kudos to all of the Title IX coordinators, because they have done an outstanding job of trying to prepare for this. They are reaching out to resources to try to help have these things in place by August 14th. But it's certainly, you are absolutely correct, Regent Flores. This is impactful to our institutions.
Well, I have to say that what I've noticed in working with them, that attended one meeting, and I followed what the emails and everything that was exchanged back and forth among everybody. And Nellie, why don't you talk about the collegiality that's developed and the willingness, especially on the part of the larger campuses, to share with others information from some very detailed PowerPoints on different subjects. So I'm optimistic about.
Right, I
that.
agree. Dr. Gomez, you're correct, because the level of collaboration among all of the campuses and the timeline coordinators' offices has been absolutely impressive. They have been very much aware of the fact that they are going to have to implement these very challenging policy now. It is challenging in the sense that there is a burden being placed upon us that wasn't there before. We accept the burden. We understand the reason for it. We acknowledge that it's important, and we're going to do everything we can to carry out all of the requirements of everything that's in the policy. Of course, we're going to do that. And to their credit, the timeline coordinators have absolutely come together to ensure that they are all making each other aware of the resources that are available. And that's what's going to help get everybody to where we need to be, both in the level of training and also in implementing the processes by this new sexual misconduct policy.
Okay,
Thank you,
Nellie.
Yes, that was my main concern, that I have no issues with what we're doing in rules and regs, but I just would like to make sure that as a board and as a system, we're giving our components the resources necessary to be successful with implementation of this new mandate. Thank you, Dr. Gomez.
And again, I think that's an excellent point. I would also point out, and this is new to us, these rules, although, as I said, we've been discussing them for quite some time. But the other thing that we've done through the Office of General Counsel, and we have had 3 or 4 system-wide training conferences thus far. Even in the light of the last hurricane, we were able to reconstruct and to provide that kind of training. It's just going to be a very labor-intensive office, and a collaboration between the Office of General Counsel and the Title IX coordinators and the campuses to make sure that we get all that covered. But we will continue to stay on top of it, and if we have a problem, of course, we'll discuss we'll discuss whatever those might be with system and campus administration. But thank you for that question. I think that's a particularly significant one for the smaller campuses in particular. But we will be watching that very carefully.
Thank you. That makes me feel a lot more comfortable. Thank you.
Thank you, sir. Now, if you will take a moment and turn to R&R 66. Now, we've just been discussing the sexual misconduct policy itself. On R&R 66, we'll begin to talk about the impact of that policy on the rules and regulations of the system. Okay, are we there? Give you just another few seconds.
I'm there.
Okay, what you're looking at is Chapter 4 of the Rules and Regulations, and Chapter 4 relates to the authority that the board has delegated to the presidents. And you've got, and the president currently, before this federal Department of Education initiative here of these rules, the president's had authority to suspend and remove people from campus if those people were causing a danger to persons or property or an ongoing threat to disruption of the business processes of the component. And so what we're adding here, you're looking at subsection B is new. And what this does essentially is that this is the removal process that the Department of Education has mandated in Title IX cases. So we're going to treat Title IX cases differently than we're going to treat other cases. And the challenge here was to make sure that both groups of students or both groups of faculty get the same process, essentially whatever the charge is. But what the feds have told us we have to do are essentially the following. One, we have the authority to suspend or remove, provided the person poses a health or safety threat. So that's the first criterion. Secondly, the president has got to review, or not the president, but administrative review by someone delegated by the president has 72 hours in which to review whether that removal was proper. So in other words, the feds are telling us here, if you're going to remove somebody summarily, under our existing policy, we would be obligated by law to give them a hearing quickly, a quick hearing. And that's still there. But the feds have said, you've got to, if you're going to remove them, you're going to have a more immediate look at whether the removal was proper. So basically, health and safety threat, administrative review within 72 hours. And then the burden of proof, the third thing is that the burden of proof is on the person suspended to show the administration that he or she should not be suspended, that he or she does not pose a health or safety threat. And if he or she doesn't prove it, then what happens is the person goes through the hearing process that we've just been describing. Okay, and any questions on that? Then let's go to page 68. 68 deals with Chapter 5, and Chapter 5 is the grievance policy of the system. Now, what's important to remember here, the critical factor, the critical piece of law, if you will, that's important here is that except for tenured professors and those on contracts, which are very, very few, relatively few, principally in the faculty area, that every employee on your campus or in your components, at your components or in system administration, is an employee at will, and you don't need a reason to remove. Now, what you're looking at here in 2.14 close parentheses is the system grievance policy. This applies on every campus, and what Texas law says currently is that anyone can grieve terms and conditions of employment. That's a grievance policy, and the difference between a grievance policy and a hearing process is that a grievance policy, the president appoints somebody who will look into it and then come back to the president and say, well, these are the facts, and the president makes a decision. You don't get a grievance or you don't get a hearing if you're a rank-and-file employee or if you're an untenured or full faculty member, somebody of that nature. That doesn't entitle you to a hearing. So all this says is that in sexual misconduct cases, they got to be processed as grievances, not as hearings. And I guess that's the principal point of the whole thing. You don't get a hearing if you want to complain that's about your rank and file, and you want to complain about sexual misconduct. Okay. Then, are there any questions on that one? The next one is Chapter 6, that's the section that deals with student suspensions and student services, student activities. It has the student code of conduct in it, and all this says is the same as the rule that I mentioned before, that the president may remove on an interim basis anybody who poses a health and safety threat. There has to be an assessment of the propriety of that removal within 72 hours, and then the burden of proof is on the student to show that he or she should not be removed. And that's it. That's your sexual misconduct policy. That the 59 pages plus the 3 interim suspension rules. Does anybody have any questions? Okay, the next rule is on R&R 71. Now, this, what you're looking at there is your non-discrimination policy, which appears in paragraph 2.1 of Chapter 5. And Chapter 5 is your chapter that deals principally with employees, but this is a generalized non-discrimination policy. Early this summer, the U.S. Supreme Court ruled in a case called Bostock versus Georgia, and found that Title VII discrimination, sex discrimination, is in fact that in fact it applies to people who because it apply on the basis of sexual orientation and gender identity. And what the court said on the 6-3 basis is that if we discriminate on that basis, that we're violating the sex discrimination portions of Title VII. And I guess what we're doing here is extending it to Title IX as well, so that it's a uniform policy across the campuses. And again, that's prompted by a Supreme Court decision. Are there any questions on that? Okay, now we're coming to the really tough things. And I know that Dr. Trouth and Vice President Pierce are on the phone, and there are 2 rules that deal with IT. And Dr. Trouth, can you please address these for the committee?
Thank you, Dr. Gomez. I'm going to defer to Ken Pierce, who drafted this. So, Ken, can you walk us through?
Certainly. So the first one, which you'll find on R&R 72. This first topic under information technology deals with accessibility of electronic and information resources. Last year, the Department of Information Resources went through a significant change to several of the components of the administrative code under Chapters 206, which deals with websites, and Chapter 213, which deals with all other electronic resources. So the purpose of what we've done here is really to codify these policies into our system rules and regulations and make sure they are in alignment. So under 19.2, paragraph 19.2, it would be adding a new paragraph, number 5, to reference the new proposed appendix, which is numbered A15, which is at the bottom of the page, continues on to R&R 73, and to the top of R&R 74. I'll just go through some of the components briefly. On R&R 73, if you find the policy statement, that's just our overall policy statement regarding ensuring the accessibility of electronic information resources that are procured or developed by Texas State System or any of the institutions. Under policy specifics, number one is really our affirmation, our compliance statement that we will be in alignment with TAC 206 and TAC 213. Section 2 is regarding exceptions. If there is a need for an exception to the rules, that exception within our system would allow the chancellor to approve or delegate that exception, or the president could approve or delegate those exceptions. And so in TAC 206 and 213, they mention delegation, but they don't really go into details. So we're staying in alignment, but general there. Under accessibility training, it just states that the chancellor or the system presidents are required to ensure that people have the appropriate training. That typically is only training for website content developers or for those in a procurement role where they're procuring electronic information resources that need to have accessibility assessments. In number 4, the new guidelines require that each agency identify what they now call the Electronic Information Resources Accessibility Coordinator. And we are now also requiring that those be identified at each institution. And under Section 5, really just affirming our common definitions as outlined in TAC Chapters 206 and 213. I'll ask for questions or comments at this point. All right, I left you all speechless, so we'll move on to R&R 75. And in this particular one, we're switching the topic a little bit, and this is a minor change to an existing appendix that we have relating to information security. So R&R 76, you see highlighted the added statement that we would like to provide. In the middle of the page, each component shall develop policies and mechanisms providing for notification to the designated information security officer of any suspected data breaches within 48 hours of discovery. Suspected data breach is any incident in which sensitive, confidential, or otherwise protected data in human or machine-readable form is put at risk because of exposure to unauthorized individuals. So the detail here is that we are ensuring that the information security officer would be reported to for any data breach that exists. What prompted this was there was an institution that had a data breach where some information was mailed out via mail. That information was eventually compromised and then copied and sent back. And the information security officer was not aware. And we're going under the premise that today that any breach of data, whether it be electronic or in paper, if exploited, would manifest itself in an electronic system somewhere or be used via digital mechanisms. So if known, the security officer can monitor and be aware and prepare for that. So we're just basically adding that any data breach, not just an electronic data breach, that the security officer be notified.
Thank you, Vice President Pierce. Okay, the next two rules, RR 78 and 79, essentially provide, as I read them, additional board oversight in the subject areas. And I would ask the Vice Chancellor and Chief Financial Officer to please go over them for the board or for the committee.
Thank you, Dr. Gomez. Yes, sir. This is the first item up. Adds and clarifies that group purchase agreements do not require the contract to go to the board. However, individual purchases exceeding the authority levels that have been approved by the board do require board approval. This is for contracts with entities that we use through state purchasing cooperatives for Staples and Dell, where they're buying routine small items. And the nature of those contracts makes it very challenging to identify really what purchase level we think we're going to have on a contract. And so we're clarifying it in board that these agreements don't, but the individual purchases do. And then the next item up is just a clarification that permanent endowments and quasi-endowments require board approval. It's required by the nature of a quasi-endowment, because a quasi-endowment is an endowment that's created by the board. But we're just clarifying this in rules so that people know why we're bringing quasi-endowments to the board for approval, as we do at the quarterly meetings and the finance and audit agenda. And Dr. Gomez, that concludes my comments.
Okay. Thank you, Vice Chancellor. And that concludes the presentation of the rules and regulations. Madam Chair and members of the Rules and Regulations Committee, and I turn the floor back to the chair.
Thank you very much. And first and foremost, let me thank everybody that's had a hand in putting forth these recommendations, and for Fernando and Nellie for doing so much due diligence. We have some aggressive action items for us to move forward with some of the Title IX requirements, and there certainly will be a challenge for the institutions, but I have all the confidence, I'm sure we all do, that the teams that are in place will manage by the guidelines and make us proud. So with that, I'd like to go ahead and move on and say that if there's any action items or any items that any regent wants to move off the consent agenda. If yes, if you don't mind, please advise me as to which amendments, if any, you want the full board to consider individually. We'll record those items. So is there any yeses? I'd like to go ahead and take that, and anything we do with those amendments will be sent to the full board for deliberations. Items not moved will remain on the consent agenda. And for now, with your permission, Regent Flores and Regent Tinsley, I move that we recommend board approval of the amendments on the consent agenda. Regent Flores?
Agree.
You concur?
Yes.
Regent Tinsley, do you concur?
Yes.
Okay. Hearing none, we will, hearing no no's. Did I miss anybody off of the roll call? Hearing none, then we will move this to the consent agenda. And with that closing, I'd like to thank everyone for calling in. And unless there's any further action, this concludes the telephonic meeting for today. And for the record, the time is miraculously 2:45 p.m. We finished on time and early. I'm looking forward to seeing everybody next week and engaging with y'all and seeing your lovely eyes. And have a wonderful afternoon.
Thank you.
Okay.
Thank you.
Bye-bye.
Thank you.
Thank you.
Bye-bye.